determines which is the bench that is to exercise judicial power.
Yeah.
But my question to you is that Section 3 seems to go beyond that. Section 3 is separate from Section 2. It actually blocks, it confers on the three-member committee exercising administrative powers to actually block the exercise of judicial powers. It's not a question of constitutional. They can say, sorry, out, nothing further, matter ends. The question is this, so this is not a question of composition of benches, that is power conferred universally on them in terms of Section 2. The question here, it seems to me, is the very blocking of the judicial power itself. Can Parliament do that? Question is maybe noted.
And
you don't have to answer. Please carry on.
I'm not answering.
The Honorable Chief Justice said you carry on with your submissions. Just note a question.
This thing, I will add one thing to it. It also deprives me of my right, which they have said that they are passing this thing under Article 10A of the Constitution. Here, if Section 3 is there, I'm being condemned. I'm not being heard.
Who is
the
that?
party is not being heard.
Who is, when you're using the word I, who is the I here?
Litigant. The litigant. Because
एक सेकंड जरा तहम्मुल the litigant, that leads me to another question. Are your petitioners, do they have an interest in the matter, or they've come purely as a matter of public interest?
No, I am looking at Section 3.
No, I'm not talking that. I'm not asking a question of the petitioners. Do they have an interest in any case why they brought this challenge, or they brought it in the public interest? What is the answer?
Answer to that is that it's a public interest.
You have no personal interest in the matter, you or your client.
I have no personal interest.
You meaning your client.
Well, let me say this thing.
I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know, we want to see.
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I am speaking for the petitioner, and I'm saying this thing that we brought this petition
in
the interest.
You got the answer. Now please proceed. I've got the answer.
In the interest that the law should take its course. The Constitution must be upheld. And I am also saying that I'm sure with such preliminary sitting there, the whole object is that first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
Khwaja, please.
We are not going to platitudes. I will not make a political speech.
Khwaja
I'll refrain from that.
Just proceed with that.
Khwaja Sahab, just a confusion which you can answer later. So what you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches, you were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and two senior judges, you have an objection to that. That's your proposition.
I think your Lordship has possibly not, I've not been able to explain. Section 2 stands on its own footing, and I have objection on that. Section 3 is a totally different thing. It takes away the powers of this honorable court. Instead of
let us clarify. Is it your argument that Section 3 affects the judicial powers of this court?
Yes, ma'am.
Curtails judicial powers of this court, because this court means the Chief Justice and all judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
That's what my point. 2 and 3 have to be read independently and separate.
Now, please.
2 in exercise of administrative powers.
Yes, ma'am.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine by me. Please don't interrupt. I've requested you please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position. So many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing, keep noting the questions and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
In fact, to be very honest,
me.
I welcome this interruption.
Can I ask you a question? Can I ask?
Far right.
Please. What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers then.
We noted this down, and in fact, I would say that the Chief Justice powers will be whittled down, as if this law goes through, the powers will be whittled down, but we will explain it. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in, and the latest one is, of course, 2000. I will continue. Let me continue. Let me continue.
Mr. Khwaja, I will add.
Then is a question.
Mr. Khwaja.
Yes.
Right side.
Right side. Okay.
I will add to it. Whether the power of the Supreme Court has been curtailed or the power of the Chief Justice has been. I think that's the moot question.
The answer to that is that it's noted, sir. It's noted, and I will only say this thing, that Supreme Court, what is Supreme Court? Supreme Court is Chief Justice and so many other judges.
We'll be sitting here till 12 o'clock.
I know that, sir. Let's
अपना argument करें. अभी तो हम section 3 पे पहुंचे.
Let me, on section 3, I will only say this thing, that this certainly is, the Parliament has taken away the power not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition, I've not even heard, and 3 judges or about 2 judges, they will decide on an administrative side and I'll be out. So the question of 184.3 will become totally redundant. This is my point. Therefore, to that extent, section 3 is present. Then next is 4. Interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court. Well, I will.
Do you object? First, say I object to this provision, or you endorse it.
I will say this, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or why not 7? Why not 6?
Please.
I object to this thing, that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just safe? Is this ultra vires the Constitution, Section 4? Say something. We should know.
On this, I will only say this thing, that putting a clause that the bench should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges?
Well noted.